we do these programs once a month, and there's evaluation sheets that you have out there, and almost every one of the evaluation sheets that I get back, every program, there's somebody or a couple people who write, please do a program on domestic relations and juvenile. I don't know what they want from domestic relations and juvenile, so I just went and got a magistrate. And so David Black is here. He's going to talk a little bit about some updates, and then we're just going to open it up to questions, and hopefully that will answer the question that you have.
Cool.
Take it away.
All right. Thanks. Hi, everybody. So I have to confess, this is probably, as I look out and see that I know all but like 3 of you by sight, this might be my worst nightmare as a group to speak to. And the reason for that is if you have a chance to peruse the materials I did prepare, I don't even feel that basic justifies how simple they are in terms of your guys' knowledge level and everything else. I wasn't sure who my audience would be today, whether it would be attorneys or lay folk, and so I kind of went with a real basic couple of outlines for people who have probably never seen domestic court and has no idea how it's laid out or what goes on over there. But as I look at this group, that's definitely not the case. So I will touch on a couple changes that are happening over there. And then, as Angela said, if there are specific topics that are more advanced that you guys want to talk about, throw some questions out. We can discuss spousal support, child support. There are a ton of child support attorneys in here. So if you want to talk about child support, I'm going to make some of them answer questions when I don't know. But as long as it doesn't get too advanced, I'll try and keep up with you guys and answer questions at that point about that stuff. The only thing I can't do is talk about specific cases or give legal advice, obviously. And then since most of you, I can tell, have been to domestic court, you'll know that just because I said it goes one way doesn't mean the other 15 magistrates and 5 judges don't do it somehow differently. So it won't do you any good to ask me anyway. With that in mind, I'm going to get away from the outlines pretty quickly. The biggest changes I think going on over there right now, I'll start with something that's more administrative. Obviously, Franklin County has gotten bigger and bigger and bigger. I think as of a year ago, the estimates were 1.3 million people. We are now easily the biggest county in Ohio. And if you've been to domestic court, you know we have currently 5 judges. We are getting a 6th this year. There will be in the election in October, there will be a new judge seat on the ballot. It is heavily contested at this point. There were primaries on both sides, and it is a contested race. We will get one more that was approved by the Supreme Court and legislature, but that one is set for the 2020 election. So by the time it's all said and done, we will be up to 7 judges in domestic court. That is purely a function of the fact that we are now the biggest county, and yet we have, some of it's due to differences in how our court's set up, whereas to say Cuyahoga, which is still probably the 2nd biggest county, their system is bifurcated. They have a separate juvenile court with 5 or 6 judges there. They have 5 or 6 judges on the domestic side. We obviously have the one court where they do both, so they pull double duty. They work very hard, and we need more of them because we now have a huge population. I think I gave a presentation back in April to a bunch of magistrates, and if I remember my stats correctly, there was something between juvenile and domestic, like 44,000 cases coming into our system over a year's time and being adjudicated somehow. Obviously, the juvenile court is the high side of that. You have juvenile custody cases, which are your unmarried parents. You have all the juvenile delinquency and abuse, neglect, dependency cases, and there are a ton of those that happen up on the 5th floor. You have some traffic stuff, and then you have the actual domestic, the divorce-related cases. So between all of those, a huge number of cases last year. I think that also included CPOs. You get a fair number of those, obviously. So we are getting 2 more judges. One's coming this year, one will be in 2020, and that will make us, I don't know what the word you want to use is, competitive with other counties of equal size as far as the number of judges and people on hand to serve the public. So we are actually, I know there are some staff attorneys in the back working for my judges. I'm guessing they're all very happy about that so that it'll lessen their load somewhat. On occasion, when I am duty, I have the opportunity to wander upstairs and see how much work the judges do. I wouldn't wish it on anybody, so I'm glad that they're getting some additional help in that respect. So that's I guess on the administrative side, that's probably the biggest change we're going to see, is the addition of those 2 new judges. Obviously, the political races that go with that, and with politics being the way they are in this day and age, there's always something interesting happening there. In addition to that change, there is a change. There are some statutory changes. I mentioned CPOs a minute ago. That's something that the judges handle, and that is included in that stat of about 44,000 things that come through our court. The CPO is changing a little bit. Currently, you have several types of civil protection orders. You have the civil protection order that goes through domestic court. That's for family and household members. You have a juvenile protection order, which is for juveniles and gets handled in juvenile court. 2 kids get in a fight at school. Somebody gets a protection order against the other kid, so he stops beating them up, that sort of thing. You also have civil stalking orders, which are the ones that come out of the General Division of Common Pleas Court, and those are related purely to folks who can't qualify as family or household members. Same basic outcomes, same basic forms, same basic allegations that are required to prove something. It's just that you don't have that family household member relationship to qualify for the civil protection order. So the change related to CPOs is now you have dating CPOs. And I can't tell you exactly what that is because I'm not sure they've defined it yet. I know they haven't defined dating in the statute, so your guess is as good as mine as to what dating means. And we're going to be dealing with that because those just rolled online last week on Friday. So they decided to roll that out over the holiday weekend on July 6th. So dating CPOs, I would explain them as best I can as saying that they are probably most likely similar to the civil stalking orders you got out of General Division, but they are no longer going to the General Division. They are now coming to domestic court. So the General Division, I know this is being taped, I'll hear about it later, has managed to pawn more of their work off on us and give it to our judges, my bosses, who are fabulous, wonderful people. So we now have the dating CPOs that are coming over. And like I said, instead of having a family relationship or just the straight stalking one, this is somehow a dating relationship. But if you look at the statute, I will challenge you to tell me what dating means. So that's a big change. That's more work that's coming our way. Mostly the judge's way, but we do as magistrates get some of those depending on what the judge's schedule is and how busy they are. Let's see, that can roll me into the child support changes. I was talking with some of you before we got started. They have signed a new child support statute. They are updating it after 25 years. I guess it's about time. I do not know all the details, so if I speak out of turn, one of the child support magistrates who might know more about it or has already had to deal with it can tell me. The most recent thing I have read on it would suggest that if you make below $8,600, you are paying the minimum, which has gone from $50 a month to $80 a month. If you are between $8,600 and maybe $14,000 a year, give or take, I don't know that it's changed a whole lot, but it can't exceed your income, which I'm not sure how that changes things because it really couldn't exceed your income beforehand. I guess it could. You could put on an order for more than somebody's income, but under various statutes, you couldn't withhold more than a certain percentage anyway, so I'm not sure how much that changes things. But they did change the worksheet some so that when you go across and say number of kids and total family income, those numbers change. My last reading of the changes would suggest that the Department of Job and Family Services is still trying to figure out the rest of the numbers. Is that accurate as far as you guys know?
Yeah, pretty much.
So if you have a combined family income of $60,000, I have no idea what's going to happen to you because they haven't figured that out yet. But it is changing some. The extrapolation number was $150,000 a year of total family income. That's gone up under this significantly, I believe. Is it
300 now.
I was going to say 240, but is it all the way up to 300? It's gone up quite a bit. So so that's going to change too. Beforehand, for those of you who didn't know, at 150 they would sort of cut it off. It wouldn't go up a lot if your family income combined was over 150. You had the option of extrapolating and actually figuring out the numbers beyond that if you thought it was appropriate, but that was largely discretionary with the court. Obviously, if they're raising that threshold number significantly, then some of that discretion will be reduced up until you hit that new threshold number. So there will be a whole new set of figures for numbers that we previously didn't spend a lot of time on unless you were extrapolating. And I don't, based on my experience, I would say that extrapolation didn't happen a lot on my side of things. I'm guessing maybe you guys in child support dealt with it more often than I would have. But it didn't seem to be a common thing that the judges or the magistrates did often. Some other things that I'll throw out there, I don't know how accurate they are, but it's just based on some of the stuff I've read. I believe the new numbers and some of the updates after 25 years of not changing it are going to focus more on some of the things that right now are what we call deviation factors that are sort of at the discretion of the court. It seems to me, from some of what I've read, that they may be trying to put some numbers on factors like the amount of parenting time. Currently, if you check shared parenting on the box, it doesn't change the number from a sole custody worksheet to a shared parenting worksheet. I'm thinking that might change based on some of the things I've read. They might be trying to figure out a way to work that into the actual calculations instead of leaving it so much up to a judge or magistrate to determine extra parenting time as a deviation factor of take your pick based on what you think that day. So I think there might be some changes like that. I know some of the upgrades involve additional parenting time. I think they're looking at, obviously, increased costs of daycare for families and things like that. I believe they're changing how they credit the health insurance, too. Health insurance, I'll say currently, even though the new law has been signed, I guess, but prior to this, health insurance was divided between the parties based on a percentage of income. It was subtracted and deducted from both sides of the calculation. It was calculated in as a credit or a deduction. I believe now what they're doing is the person paying is going to have it deducted from their income, so it's going to come off the top instead of being calculated later in the worksheet. And I don't know if that's going to give more or less of a credit. I'm guessing it might reduce the credit a little bit because a couple $1,000 change in income on a worksheet doesn't seem to affect it nearly as much as a couple $1,000 farther down the worksheet, like daycare or something like that, when you're dividing those by percentages and adding them to the total amount of the obligation or subtracting it from the obligation. So they're going to change how they credit that. They're making some other changes. That's about all I know at this point. I haven't read it or seen it, but the actual statute of the House bill, I've just read some opinions on it and some different stuff. So if anybody knows any more than that, they're welcome to chime in. But that's what I know so far about that change that's been signed and is coming. From a purely administrative standpoint, they're in the process of updating our computer systems. For those of you who are familiar with it, we use something called FCJS. That's not accessible by the public, but it is something that we use that gives us all our online information for cases. They had bids out. I believe they've selected a vendor, and now they're in the process of trying to finalize and get that rolled in and online. So there will be a new computer system for the employees for accessing case information and case files online. Since there aren't hard copies of files anymore, everything's electronic now. So those are the biggest changes from an administrative and a law standpoint that are coming through. Anybody have any questions about any of that stuff? That's, like I said, all pretty basic and just that's what's happening. Are there any topics anybody wants to cover today? Like I said, you guys know way more than the audience I was expecting. So do you have specific types of issues you want to discuss or questions about different things that happen in domestic court? I don't want to bore you with the outlines, like they're a little basic. Wow. All right. Let's see.
All right, I got you one.
Yeah.
With the change in the legislation, is there usually a gap in the software update, or will the software immediately reflect those changes?
My guess is there will be a little bit of a gap, especially since they're still trying to calculate the rest of the charts. The big software is obviously Piper's, or I forget who produces FinPlan. Is it West? West. So those are the two that I think most of the court computers have FinPlan, or not FinPlan. Most of the court computers have software from Brian Piper, who's a domestic attorney. He also dabbles in software. He should probably do that because I'm guessing it's way more lucrative than domestic practice, especially with all the changes he's had to make. Obviously, with the changes recently, I guess I can go back to that. Everybody's familiar with the changes made to the tax code. That affected child support significantly. So we've already had one set of updates for the worksheets to account for changes made by the change in the tax code. And then FinPlan, in addition to child support, runs worksheets for people who are trying to figure out some spousal support. Those worksheets obviously had to be changed because of the same tax code changes. So when they update the child support information, yes, they'll have to. I will give both companies credit. I would guess that I have updated both already on my system. I know West came out with updated FinPlan stuff within a month or two of the signing of the new tax bill. I would guess I've had access to that since March, April. And I think Piper updated his software pretty quickly too. I think the biggest change at that time though was just the treatment of dependents for tax exemption purposes. There weren't a whole lot of other changes, so that might have been an easier fix. I don't know how long it'll take somebody to fix something if they upend the better part of the calculation. And I've done it by hand once or twice, but I can't tell you how they figured out a computer program to do all that and factor it in. So somebody smarter than me, clearly. Anything else on child support or? Let's see, other things. This is not terribly new, but we have, and again, I might rely on you child support guys because I don't ever get to deal with it, but I know Judge Jameson has the Compass program, which is, I think, a really good program from everything I've read, and I believe it's focused on folks who have trouble paying their child support and helping them get through maybe some of that process before they go to jail. I've heard it's been successful. I've seen it written up in the newspaper as being a positive thing. Mr. Eby's back there smiling at me.
I'm not going to comment.
Fair enough.
But it is Judge Jameson's program, and it's for people now. You have to have been found in contempt before you're put into the program.
Okay, and so that was my understanding, that it was folks who are already in some trouble and are probably at risk of going to jail. And although sometimes that is necessary, obviously, if you're in jail, you don't have a job, you're probably not paying. And I know part of the emphasis, even with the changes in the child support statute, at least the alleged point of some of that, in addition to just updating our numbers after 25 years, was to increase the rate at which people pay. And anytime you read something on the new statute and why they've done it, they start talking about the percentages at which people actually pay based on their income levels and how much isn't being collected, and that they hope that this will help collect more of that and have less people in default. I wouldn't hold anybody's breath or your own. I'm guessing that my child support colleagues back there will have plenty of work to do in the future because people just don't pay. And it's not going to matter much if you change the statute around a whole lot. So, so Judge Jameson has that program. I don't know how many of you are familiar with JDAI. That's the Juvenile Detention Alternative Initiative. That is Judge Gill's program because she's the administrative juvenile judge. That program has been around in some capacity, in some shape or form throughout the country for upwards of 25 years. I want to say that it's been around here in Franklin County much more recently. We were actually one of the pilot programs around here. Judge Gill does a really amazing job with that. I know it keeps her very busy in addition to her other duties. And the whole purpose of that is just what it sounds like. It is trying to find things to do with at-risk youth besides ship them off to Department of Youth Services, where you have the same issues you do with adults who go to jail: recidivism, lack of progress, basically. So that program is in full swing. There are always conferences. There are different counties now being added to the groups who are doing it. And that's obviously changed some of the juvenile court procedures and how they deal with young people who come through their system with delinquency and felony charges, things of that nature. So that's a big program, one of the services the court issues. Another juvenile court program that's, again, not new but fairly helpful is the drug court program. That is largely for parents who are dealing with children's services because of drug and alcohol issues. They've probably lost their children for some period of time, and it's an alternative to going through some of the other juvenile court procedures. You go through drug court, you do everything you're supposed to do, you meet with people, you pass that, you get cleared, you get your kids back. Sometimes you get them back before while you're making good progress. But that's just another program that they offer folks here in Franklin County, as opposed to making them go through the straight juvenile court process with children's services. You'll have to tell me more.
And that they keep changing the name, it's now Recovery Court.
Right, they just changed it to Recovery Court. So when you go on the court's website, you'll see stuff now about Recovery Court. They just changed the local rules to say Recovery Court. Do you still deal with children's services in a case plan, or is you're completely pulled out of that process?
No, I mean, they still have to follow their case plan, but there is a liaison from SCCS there that actually can get parents moving a little faster in some aspects. They can enlarge visitation, they can make changes.
Okay.
That not necessarily, your ongoing caseworker would be able to do that.
Right.
They get things moving a lot faster. It's
right.
basically where it goes, and there's a lot more hands-on. Cindy Van Cleve is like, whoa, amazing.
Is she the new director of it?
She is.
All right, see, I hadn't dealt with it much since Monica was there.
Yeah. No,
and she has one person working with her?
Correct.
Okay, so it's the same setup it was before when I knew who everybody was that was working out of it. Magistrate House is the magistrate that deals with it. She's also your traffic court magistrate. So those are her two functions. And as Stacy said, it is an expedited process. When they first started it, there was a lot of pushback from attorneys. They were worried that this was somehow an extra thing and it put more of a burden on their clients, and that if they were having some effect on getting their children back or successfully completing their case plan because they had to do these extra things and they didn't like it. But I think most of that has fallen away. I think that in large part it's a less threatening process than going in front of some of the other magistrates for shelter care hearings or annual reviews or things like that. The addition of the new director and their assistant is that you have somebody working with you, meeting with you regularly, going over stuff, making sure you're staying on board with things. I will tell you, a long time ago when I was in private practice, I had people go through that. Very nice lady, could not get her straightened out. Just, we couldn't figure it out. We tried, a bunch of us, and I will give drug court, now Recovery Court, all the credit in the world, because the folks there figured out that she had mental health issues, mostly from events that had happened previous in her life, things she had seen, witnessed, been exposed to in her own family. But she kept them pretty well hidden. She didn't present as having those issues. She was of above average intelligence, but every so often she would relapse on coke and alcohol, and they'd come in and take her kids again. And this case went on forever, but it was, we'd do well for 3 or 4 months, then she'd relapse, then we'd take her kids away, and she'd do well for 3 or 4 months, then she'd relapse. And it wasn't until the drug court folks really got a chance to investigate her thoroughly and interview her and work with her in a counseling kind of setup that they determined there were these issues, and that really it was those issues that kept causing the relapse. And once they addressed those issues and got her that counseling, the relapses stopped, she got her kids back and successfully completed the program and is out of the system. So not necessarily something that would have gotten caught going through the regular system where you have a certain amount of time to deal with people. You have guardian ad litems who are on appointed lists, who are running around like chickens with their head cut off trying to meet with all their wards. So another good program that's offered to the residents of the county to deal with those issues. Any questions so far? Nobody has any issues that they're curious about in domestic court? Yes. Love it.
With the change in child support,
yep.
We're still quite a ways before it's implemented, right? About 9 months, 6 to 9 months?
I would imagine at least that.
That will be considered a change in circumstance, correct?
I would imagine.
So I'm expecting that you're going to expect to be very busy.
Yeah, change in circumstances is defined as a 10% change or any other thing that the court finds would warrant a change, basically.
I'll start calling my prior clients and start preparing the motions.
Yeah, you just have to be careful, because I know, like I said, reports are that some people have theirs go down, depending on how they start trying to quantify some of these factors that maybe currently are more discretionary as deviation factors. But some people are definitely going to have theirs go up, so you may not want to rush to file it till you have the calculations and can check them yourself. But I would imagine that the changes are significant enough. Probably everybody who is right at that $150,000 threshold for extrapolation and is now going to be under the new threshold, I'm guessing theirs are going to change significantly. So I should see a lot of those cases. I don't know about all the others. It might not change it that much, but I suspect, based on what they're talking about, that it's going to have a significant impact on almost everybody's. Which ones?
The ones extrapolation under 300.
I would imagine it's going to go up, because mostly what you had is at 150,000. That I don't want to say the worksheet stopped,
Yeah.
because if you were at 170, it was still more than you were pulling at 150, but it wasn't going up at the same rate as it was before. So somebody who was at 160 this year as a joint family income, you know, they might have a $1,500, $2,000 a month, depending on some of the other things. I'm going to guess those are going to go up now, because you know, they're going to actually put in specific numbers for those folks up to 240, 250, 300,000. So, and once you got up that high, frankly, you probably have extrapolated or deviated up, or you have so much spousal support or something else going on that it might offset these changes. But at least for that $150,000 to $250,000 income group folks, I think some of those folks are going to see an increase, because they were probably getting a little bit of a break with the statute, for lack of a better description, cutting itself off at that threshold.
So aside from the health insurance, as the spousal support factor changed?
No, I don't believe the spousal support factor changed. Spousal support has changed for a different reason, and that is that the most recent change in tax law says that spousal support is no longer going to be income to the receiver and deductible to the payor.
I mean, in the calculation on the child support worksheet, you know, the spousal support.
Well, if it's not income, it's not going in there anymore. So that's what I mean by it's going to change that.
Oh, I see.
Anything after the end of this year that comes on as a child support order, you're not going to be giving credit for spousal support paid and received, because it's not income. Probably a deviation factor at that point. Certainly, we've talked about with the judges that until we figure out a better way to deal with the fact that the dependency exemption has gone away, we've talked about that potentially being a deviation factor. So it's not that it doesn't still apply. And we still denote in our orders who gets to claim dependency exemptions, because you still have state exemptions and other things that apply in that situation. There's been a little bit of debate about some of that, because there are other exemptions that I wouldn't describe as dependency exemptions. And I'm not sure the statute really authorizes us to award those. And I would suggest that there are federal statutes that apply as to when you can take some of those and when you can't. And I don't know that a domestic court magistrate in all our glory saying you get it and you don't really changes any of that or affects it, or should even play into that at times. I don't think we should be, unless we're going to read the federal statutes real carefully and make sure we're following them too. I'm not sure we should be doing that. But I think that the best answer I can give you to that is that, at least from my bosses, we are still designating somebody as the dependency exemption recipient for the state ones, and then for whatever the heck else they can qualify for when they do their taxes.
This doesn't seem quite fair. Well, nothing's fair in this court, but...
That's not true. Everything is fair and equitable.
Yeah, exactly. Or at least we all sign off on that. But regardless of what the IRS is going to do with the spousal support, calculation of child support, if my client, typically the husband, is paying $1,000 a month in child support, which is $12,000 a year, that should, in the calculation of child support...
You mean spousal support?
Yeah, spousal support, I'm sorry. That should come off in our calculations, because our calculation is, we're not governed by the IRS, that's just a tax issue.
Right. And I guess that will depend on whether or not.
Otherwise, you know, our claims, the obligors are double paid.
Right, and they're not getting any tax deduction for it, which is the only reason that you don't absolutely abhor having to pay spousal support as the paying spouse, is it's actually less painful sometimes than child support because you're at least getting the tax break off the top.
Right.
No, it's an excellent point, and I will tell you that I think the problem with that is going to lie is, although we're not bound by the IRS necessarily, we are bound by the statute when you're talking about what income is defined as in the child support statute and in the.
That changed 3119. Did that change 3119?
Well, I mean, yes, I think that's what's being changed is that whole statute.
So they're redefining.
I don't know if they're redefining income, but that's the statute that's changing. And so if they don't define spousal support as income somewhere, then it's not income anymore. There's a specific line for it now, spousal support paid, on the worksheet. I don't know what they're going to do with that, but if it's no longer income, the reason you include it now is because it's income.
So these legislatures, they don't know what they're doing because they're the ones usually paying child support anyway.
Everybody can agree on taking a knock at politicians. Fair enough. Common ground. I love it. I don't disagree with you, and that's why I said I'm guessing it will still be some sort of grounds for deviation, or it'll have to be factored in some way, somehow. If it's still considered a source of income, then you're still going to put it in there. But what will happen, see, if just considering a source of income solves half of your problem. It'll go on, let's use your example, the ex-wife's side of the ledger as income to her, but it's not going to go on his side of the ledger for spousal support paid anymore if there's no credit for it. So it might still be considered income to her, but then there's nothing that says it has to be deducted from his side at that point.
I'm just trying to IRS here, 3119 here.
Right.
I'm trying to draw that right.
Right, but remember there are two parts to the spousal support. There's the part where you get credit for paying it on the worksheet, and she has to take it as income for receiving it. The income side of it may not change. It still may be considered income under the statute as it's defined for her, but if it's no longer tax deductible, it's no longer deductible from his income, then he's still going to have to put his full income in, and he's not going to receive the credit he currently receives, at least. Because what it does in the child support statute, what it does right now is it reduces his income. It comes off the top. Instead of 160 a year, he makes 140, and then you base child support on that. I think the way it's going to stand now is he's going to make 160, and you're not going to pull that 20,000 or 12,000 or whatever it is a year off. James.
Well, part of the problem is we've had 25 years of the statute the way it was based on an intact family that was married in calculating child support, and over half of the children that you're sending support for are from unwed mothers, and so there was never an intact household to begin with.
Right.
But we only had one set of guidelines to use, and so the new guidelines and the legislation is supposed to be trying to remedy a lot of that problem. And so I don't know if there's any really good way of doing it, no matter how you do it.
There's still going to be, there will always be issues, and I don't know how much the new statute is going to change how spousal support's affected. I think the change in the tax code, and I understand we're not bound by the IRS, but the tax code is still a federal statute, and we are somewhat bound by those when they're brought up. So I mean, if it's not income anymore, but I agree with you. The legislature will have to address that, hopefully as clearly as they did when they defined dating relationship and civil petition orders for dating. Yes, sir.
What are they doing with other children in terms of the credit?
You do not get that credit now under you do not get that credit under the change in the tax code. So other kids, because that's basically the credit you got on the worksheet, correct me if I'm wrong, was the dependency exemption amount, basically, was factored into the worksheet. When you checked the box that said, I have 3 other children born to and living with me, that was just giving you the dependency exemption, the federal dependency exemption for those kids.
Zero.
So now if you go in and do a worksheet, and that was the thing Piper and FinPlan had to change on theirs, you can check a box that says use the 2017 numbers, and you can actually get dependency exemptions put back in. But if you don't check that box, there's just a 0 for the number next to that box. And so you don't get, which is why I said I think the last thing that the judges and magistrates all discussed in as close to a group setting as we ever get was that it's most likely going to be treated as a deviation factor by us now. Additional costs, other expenses. I mean, if you're going to take the fact that you have a new spouse and I have to consider her income as part of the deviation factor, then I should probably consider that you have 2 more children as part of that deviation factor too. And back in the day, we probably would have looked at them and said, well, you have to support this family first. You shouldn't be having more kids in a new family. And sometimes we still say that when they're way behind on their child support and making excuses. But right now, the best we can do with it is make it a deviation factor because there's no credit for it on the worksheet. And I would imagine, I haven't seen anything that the new worksheet is going to somehow undo tax law and change that. So I wouldn't anticipate that changing going forward. I think it's at best it's going to be a deviation factor or nothing else.
Well, can't Ohio just establish its own figure?
Sure. I mean, they could change it as part of the amended statute. They could say that you get credit in it for the state tax exemption for a kid. I mean, they could plug that into the worksheet and make that a credit that they give on the child support worksheet. I haven't read anything that suggests they're doing that, but I think those are the finite details that they are not even close to completely finalizing yet. I don't think they've determined that or how much credit they might give for shared parenting, or at least if it's not shared parenting, additional parenting time. As we all know, shared parenting doesn't mean anything. I mean, in the grand scheme of things, you could have your kid once a month and call it shared parenting, so I'm not sure why that would be a factor in a child support calculation. It's really more an issue of, do you have your kids half the time and therefore the cost of feeding them, and are you sharing in the cost of taking care of them, or are you seeing them once a month and you literally have to pay for nothing? You're just fun on a weekend. So I don't know if they're going to do it as part of a shared parenting thing or they're going to do it specifically based on the extra amount of time. And then the question becomes, what's extra time? Because we've sort of muddled around in the past, I forget how many years ago now, 3-4 years ago at least, we revamped Rule 27 and 22. Juvenile Rule 22 is the model visitation schedule for juvenile court, 27 is for domestic court. Now you have 4 options. It used to be that the standard rule was Wednesday night and every other weekend for one parent. The assumption was one of you was a lousy parent and you were getting 1 night a week and every other weekend, and you sort of, right or wrongly, had the burden of establishing you should get more. I think we've largely moved away from that. I think now with the 4 options, you have 2 of the options are basically 2 different versions of 50-50 parenting time. Option C on the visitation schedule is the old 1 night a week every other weekend, and then option D might just be every other weekend. It might take out the midweek. So when they redid the model visitation schedule, they sort of changed what the presumptive amount of parenting time was anyway. So if you come in and tell me now that you're doing 2 days a week and every other weekend, and you want to go to 3 days a week or 4 days a week and do something, or you're going to do week on, week off, are you really exercising more parenting time than you were in the first place? It might have been reorganized, but it's not additional parenting time. And if you ran the worksheet and figured out child support based on the straight guidelines when you did the original divorce decree, for example, then I don't know that you doing week on, week off at that point becomes a real big change in circumstances, because you already had half the time. You know, if you had 1 night a week and every other weekend, sure, now you're taking on an extra 3 days a week, but you know, all that has changed. And of course, while we're knocking legislatures and politicians, every time they change one thing, they fail to understand that it affects 5 other things, and they don't think to change that. So, you know, they make changes to the model visitation schedule, but they wait 4 or 5 years to address child support. Not that child support and visitation are actually always intertwined. I mean, they're separate. You just because you're doing one or the other doesn't mean you have any rights with regard to the other one. But by the same token, one of the biggest deviation factors we always hang our hats on and use more than probably any other factor is additional parenting time, followed closely by in-kind contributions. If your child support's going to come down from the guidelines, that's usually the two places that it comes to absent an agreement of the parties. That's usually where it happens. I'm exercising more parenting time than the standard rule. Well, now the standard rule has 4 different parts to it. Which one's standard? They didn't really address that. I guess technically I think we're still treating standard as 1 night a week and every other weekend, so if you're doing more than that, you're probably going to be arguing to me that you want a deviation on your child support. And Melissa and James will be back there saying you're crazy, support your kid, and I'll be like, they're right, especially since they helped me out today on all the stuff I didn't know about child support. So, that changed. Now they're going to change child support. They changed the tax code. Even back when they did the Affordable Care Act, it had effects on child support. But they didn't, at a federal level, they weren't really too worried or caring about what happened to those of us in Ohio when we had to figure that stuff out. So, this will be another instance where they change something and we'll have to make do. I hope the legislature either clarifies things or cleans up places where there are conflicts in the statute, or we'll wait for the Supreme Court to weigh in on it and tell us which way it's going to go. Right. And then we'll figure out what dating means too. You tell them real excited about that.
Is that a new section in the code, or is it just added on?
They added into the statute.
To the current statute.
And I looked at it again the other day. I actually had a cheat sheet from my boss, one of my immediate bosses, because I was the duty magistrate last week, and it was likely that the duty judge was maybe going to be either out sick or not available. So I was prepared to have to do CPOs all week. I did a bunch Monday, but she was back Thursday and Friday, and I didn't actually get any, but Friday would have been the first day for them. So they moved those from general division over to us on Friday of last week. And I looked at the cheat sheet and the information, and dating relationship. I'm guessing, depending on your gender and your opinion on things, dating relationship can take on a lot of different things. Did you go out to dinner last night? We're dating.
Online.
Yep. We've talked 4 times online. We're dating.
The dating websites that you made.
Dating website. We went on a date. Are we dating?
Oh, but you've had very intimate conversations online, and then all of a sudden you start getting harassed.
Yeah, and I don't want to get this too far off of it, but you've been hanging out for 6 months, you've gone to dinner twice, you have a certain kind of relationship. Are you dating?
It's all subjective.
Or are you just friends? I bet neither. I would guess if you ask the 2 people in that relationship, you might get 2 different answers.
But the standard is subjective anyway. Yeah. Right? It's what would a reasonable person, this reasonable person think.
I suppose that's the standard. I mean, I don't want to knock my own gender, but that disqualifies every male magistrate from ever making a decision, right? I mean, if we knew anything about women and dating, you want me to make a subjective decision? I got married so I wouldn't have to figure that stuff out. My wife tells me those things now, so I don't have to guess. I mean, you're right. I have no idea. So it's going to be, well, with everything else, I think it'll be probably fairly open-ended. I haven't talked to any of the judges about it.
Well, the biggest gap, though, whether it's dating or not dating, you've got a person who's been threatened or maybe even harmed, and if you got one court saying, we don't have, this is not proper venue, you need to go over to the regular side, or the other side, not regular side.
Yeah, we'll call them the regular side. We're the redheaded stepchildren. It's fine. We can admit it.
I got read the right act when my lies. She was, just because they're the general division doesn't mean that we're not as important. It's all a court of common pleas, so be on time. Anyway, it was a long time ago. She made me cry, and but I mean that's the thing. You've got the poor person hanging in the balance. As long as the ex parte is being continued.
As long as something's being done, you're right. The problem is, when have you had somebody go to one court, ask for something, been told this isn't the right place, they send you to another place, you get over there and they're like, we're not going to do it either. And that's going to be, my immediate boss is Nancy Novak. She's the lead domestic magistrate. She's the one that deals with all the CPO clerks. She's responsible for them. She hires them. She fires them. She makes sure stuff's running up at the CPO desk. She has been in constant contact with the folks over in General Division who run the civil stalking order desk. I doubt that's going to be a huge problem because I know they're working very closely together to make sure that this gets switched over, and if people go to General Division and need to come to us, they get walked over. We're trying not to lose anybody in that shuffle. So I don't think you're going to see a situation where you go one place, get told no, go to another place, get told this isn't right either. I think the bigger issue, and see, you had to tape this. I think on the magistrate level, there is a sense of it's an ex parte order, and I'm going to punish whichever judge made me do work today. So if it's reasonably close to a dating relationship, I mean, look, the household and family member definition is so broad. If you've lived together in the last 5 years. So I'm guessing that we're going to take an equally broad, the judges haven't said this, but we're going to take an equally broad reading of dating relationship. And at an ex parte level, the standard is so low, there's nobody there to debate what you're saying. You're probably more often than not, if you can show some appreciable need, some danger to you, you're going to get it granted, as you said, and then the judge can deny it or send them somewhere else if the judge feels that it's, like I said originally, I don't know that they're that different from a civil stalking order, so they've got to be covered under one of the orders. So somewhere they're going to get their order. So I don't think, it's not going to be a huge deal, but it'll be interesting to see how judges start defining a dating relationship and whether or not that gets clarified over time. So, any other questions? Anything you've run into in domestic court? Anything you just can't fathom why we do what we do?
How do you address a situation where you have a guardian and one side can't pay the guardian fees and the trial's coming out?
Great question.
How do you limit the evidence when the other side's asking for that? When the other side can't pay and they're just overwhelmed financially?
Sure. So this is one of the few things I think I can say about most of the magistrates on my floor as a general statement and not be too far off as far as accuracy. There is a prevailing belief that each of the parties needs to pay something. You got to have a horse in the race, dog in the show, pick your phrase. You need to be involved, and you have very little incentive if you're getting a free ride. We do obviously have home investigations through that group. We've started using a lot more pro bono guardian ad litems to help with that issue. But if at a certain level you should be paying something and you need to pay something and you're not, under the current rules, you have a couple options. Provided you give notice in your previous orders, you can dismiss their motion, you can limit their testimony, and when we limit testimony, we are typically talking about you, the client, may testify, and you may cross-examine the other party. But we're not going to let you call 15 of your family members in there and make it a 3-day trial so the guardian's just eating their fees. That's not fair to them. They work for a living too. And you're not going to get to cross-examine everybody else that comes in. You're going to lose some ability to participate in the case so that the case gets expedited. And then at the end of that, we have the ability to order them to pay it as child support if we want to reduce it to a judgment. The guardian can always file a contempt. Then you have a purge order, and you're looking at jail time if you don't pay it. The exception to all of that, of course, is contempts. You never want to limit testimony or any rights in a contempt case because they're quasi-criminal and you're talking about jail time. So if I have a contempt and another motion pending, I might be one of the few times I'll bifurcate a hearing and do a contempt separately so I don't limit anything inadvertently in the contempt case and give you your fair shot. And then in the, but presumably, depending on the issue, you won't need the guardian for the contempt case anyway. And then in the custody or visitation case, you can go ahead and limit. I have a very extensive case management order. It's probably a couple pages long. I stole it from a retired federal judge who gave a presentation at one of our magistrate CLEs. It goes through payment of the guardian, it goes through discovery and exchanging trial notebooks. I love it, but it's also a little burdensome at times. I almost hate putting it on people because it actually requires you to have stuff ready like a week or two in advance. And I know when I was an attorney, I wasn't ready for a trial 2 weeks in advance, so I don't really expect anybody else to have all their trial notebooks together then either. But that's going to change because the new Supreme Court rule, Superintendent's 48, which governs guardian ad litems, is going to make it, I believe it's going to be in there that you cannot dismiss a motion on somebody. So at least that option will be out the door. And I will say that across the board on my floor, and I would say this for all the magistrates in domestic and juvenile court, if the guardian comes to me with this issue, but tells me that there are significant issues regarding these children that need to be dealt with, I'm going to find something else besides dismissing the case. If the guardian comes in and says, there's no case here to begin with, these kids are fine the way they are, if nothing, single thing changes, they'll be fine, then I feel fairly comfortable saying, you haven't paid the guardian, you're not participating, you're not doing what you're supposed to. I gave you a warning 6 months ago, I put it in an order that I might dismiss your motion if you didn't start paying them something. You've paid nothing, I'm dismissing your motion. It's without prejudice, you can always refile it and start over. I'm fairly lenient. If you've paid something, if you've made any sort of a good faith effort, if you've tried to work out a payment plan, a lot of our guardians, despite their better judgment, will take payment plans. If you do any of that stuff, it's probably not getting dismissed, but I will admit that I'm probably the worst offender. I will dismiss stuff more often than maybe any of my colleagues. And the handful of times I've had to do it, I've been upheld by judges on all of it, so I'm not concerned about doing it at this point. Now, sometime this fall, Superintendent's Rule 48 is going to change from the Supremes, and when that happens, I will be unable to dismiss your case on you. But I believe I will still be able to limit evidence. I can make you pay the guardian child support. I suppose I could keep continuing your case. I could stay your case. I have to be careful about how it shows up on mine and the judge's stats, but absent that consideration, I can probably do as much as possible. I can instruct the guardian not to do a whole lot of stuff on your side of the ledger. I'm not going to have them go out and do a home visit unless the other side wants it. I'm not going to have them go out and interview all your witnesses. I can certainly order that their work is limited, their scope is limited based on what you are and aren't contributing to the bill. So I think there will be other avenues, but shortly you won't be able to dismiss it. I will be the first one to admit that when they asked for comment on that rule, I wrote a very nasty letter telling them they were all crazy over at the Supreme Court. So I'm sure they all love me. Anything else, guys? We still got about 5 or 6 minutes for your free 1-hour CLE. Are they changing it for you guys? I know for magistrates and judges, they're talking about bumping it to 40 hours. Are they going to do that to you guys too? Because you guys don't have anything better to do than go to CLEs. It's not like you have to work and bill clients so you can make a living.
24 to 48?
40.
24 to 40?
40. They're bumping it to 40. Every magistrate seminar I've been to in the last year and a half, that's all they talk about is they're going to bump it. And listen, while I'm already on the Supreme Court's case, I'm fine with that. Please bump it to 40 if you think it's going to improve the practice of law on both sides of the bench. But for the love of all things, would you please start offering CLEs that don't stink? I've sat through so many CLEs where it is so, and it's sponsored by the Supreme Court, and God love them, they do a great job up there, but none of them have ever practiced law in real life. I mean, they do very, very important, very witty things that require way more intellect than I will ever possess, dispersing the law of Ohio all over the place, and they do an excellent job. But when it comes to telling us how to do things, when they start meddling in our local rules or how we appoint guardians or dismissing a case because you don't pay the guardian, to me it reflects that they just don't know what we're seeing at this level and what challenges we deal with. You want me to get a case done in 9 months on a custody case? You want me to actually try the case and have a written decision inside your 9-month time frame? Then give me some way to make people move. And if I can't force you to pay your guardian, and I can't force you to do discovery, and I can't force you to do anything else, then I'm going to have a hard time getting anybody to do anything inside of 9 months, let alone me write it. So sometimes they're CLEs. They're CLEs for guardians. This is a big thing we've talked about on my floor a lot. We have a ton of people on our guardian list. Many of them do a fantastic job. I love having them on cases. They help resolve things. But there are several who are just not good at being guardians. It's not meant to be mean. And it's not their fault, because frankly they do a 6-hour class sponsored by the Supreme Court, which back when I was in private practice I sat through. I had already been a guardian for 8 or 9 years when they created that requirement. So I had a pretty good grasp. I learned from some pretty good and well-respected attorneys how to do it. I'd gone with them on cases. I went to the class and all the information they gave me was absolutely opposite anything I would ever do in a case. And it was taught by social workers, and social workers have their perspective on how you deal with kids and how you treat kids, and that's all very valuable, no doubt. But it's not real helpful if you don't know about court cases and what has to happen. So I got a bunch of advice that I thought was not real helpful. Then every year you sit through a 3-hour class. You make sure you do your pro bono work, and there are a couple other requirements, and you're on the guardian list according to the Supreme Court. You are qualified to be a guardian and deal with children. Okay. There again, if you're going to make rules like that, do some real training. You know, if you're going to make us get 40 hours, you got to offer me better speakers, better information, something that I can practically use every day to do my job better, to help you guys, to help your clients. And if you can't do that, then you're not going to make any of us better lawyers by making us sit through an extra 16 hours of classes. People who are ethical, responsible, diligent, hardworking are going to be those things. Folks who aren't somehow going to pick up the bug because they spent an extra 8 hours hearing from somebody from California about how they do cooperative law and all play nice with each other out there. That's fabulous. Love it. Not helpful.
And charge more.
Yeah.
Right.
That's a racket. That's my theory.
It is. And listen, some of their programs are great. I've been to the last 2 magistrate conferences I've been to have been phenomenal. I've come back to work refreshed, ready to get work done. I felt great. I was happy about my job. But I've been to conferences where I, started looking at the wave pool they had in the adjoining hotel and thought, I might go for a swim this afternoon. Just not going to be able to sit through another half hour of this. So, we'll see, but that's coming. I didn't know if it was coming for you guys or just the judges and magistrates, but it's definitely coming. So you'll have to do this 39 more times. Sorry. Thanks, guys.